Good afternoon. Well, good afternoon. Thank you for being here today. My name is Rick Snyder. I serve as the president of the Indianapolis Fraternal Order of Police. On behalf of our entire membership, I thank you for being here. I also appreciate the great attention throughout our city as to the reason why we joined together today. As most of you know, just earlier this month, on August the 4th, our FOP membership directed the leadership of our organization to convene two separate votes related to confidence of law enforcement officers throughout Indianapolis and Marion County on the Marion County prosecutor, Ryan Mears, and the Marion County court system. As many of you know, this came on the heels of a tragedy that occurred in central Indiana, and much has been made to do about that by others. But suffice it to say, it's very important to note that this is a result of repeated incidents and fractures within our system, as well as failures to act by our Marion County prosecutor. We're going to discuss some of those examples, but before I do, I want to make clear that this vote that we're going to announce today represents police officers from every single agency, every single law enforcement agency in Indianapolis and throughout Marion County. Indianapolis FOP represents agencies such as the IMPD, the Marion County Sheriff's Office, Indiana State Police troopers who patrol District 52 in this region, Beech Grove Police Department, Speedway Police Department, Cumberland, Airport, Southport, IUPUI, University of Indianapolis, Butler University, IPS, and Township School Police, as well as several others at local, state, and federal levels. It's important to note that this vote will also include votes from the Lawrence Police Department. They are under a separate Fraternal Order of Police Lodge, the Lawrence FOP. However, their membership elected to join our overall vote, and so their vote is included in these findings, and they also requested that it stand as one unified vote result. Again, we have had no question over the last 3 years. We've pointed to several incidents of fractures within the system, failures to hold repeat violent offenders accountable, and at the same time, intentional steps taken by our Marion County prosecutor to not uphold the law of the state of Indiana, as well as intentional steps to not follow processes in place with deadly outcomes. In addition, this is at the same time that as of last year, we had an increase of thousands upon thousands more cases awaiting trial in the city of Indianapolis. Count as of last year is that we were at approximately 37,500 cases awaiting trial, criminal cases awaiting trial in Indianapolis, Marion County. If you just look at the pure math of that, it would require that we hold 142 criminal trials every single business day that the courts are in session throughout the year. That is not doable, nor is this sustainable. In addition to all of these factors, our Indianapolis law enforcement officers spent the entirety of last week conducting these votes of confidence. I'm going to walk through what the votes were structured as so that you clearly have that information and then be able to answer any questions that you might have. Again, we took two separate votes. One was on prosecutor Ryan Mears. The second was the Marion County court system. It's important to note again, both of those were at the direction of our membership, who directed that this vote take place. There were two separate ballots that were completed. The first simply asked, do you have confidence in the Marion County prosecutor? Members marked confidence or no confidence. Second, do you have confidence in the Marion County court system? Members marked confidence or no confidence. Now, oftentimes people ask about total number of votes. We have historically not discussed those numbers. We simply focus on the percentages. The main reason for doing that, and I want to make sure people are clear on that, is because we really want to avoid from vote to vote to vote, comparisons being done of how many people voted, how many didn't. What I can tell you safely is that hundreds upon hundreds upon hundreds upon hundreds upon hundreds, it just goes on. I think it's safe to say several hundreds of officers participated in this vote, and these are the outcomes of the percentages involved. And it should be noted that these votes then speak for our entire membership. Do you have confidence in the Marion County court system was the second one. So, first up, do you have confidence in the Marion County prosecutor? Only 1.1% of officers voting said they had confidence in the prosecutor, meaning that 98.9% of our Indianapolis Marion County law enforcement said that they do not have confidence in Marion County prosecutor Ryan Mears. Do you have confidence in the Marion County court system? The outcomes were 3.5% of our entire membership have representative confidence in the Marion County court system. As a result, 96.5% made clear they have no confidence in the Marion County court system. Again, just to recap, police officers countywide voted. 99% have no confidence in the Marion County prosecutor, 97% no confidence in the Marion County court system. Therefore, on behalf of our entire membership, including the membership of Lawrence as well, thus representing every police agency in Indianapolis, Marion County, citywide, countywide, your law enforcement officers have voted to make clear they have no confidence in prosecutor Ryan Mears. In addition, the same number of officers, all agencies represented, have voted to make clear they have no confidence in our Marion County court system. I have to tell you, I do not report this lightly. I can assure you our membership has not taken it lightly. It has really left me heartbroken in a lot of ways. I have never seen our Marion County criminal justice process in the shambles that it's in right now. We have watched countless residents be victimized by this system. Preventable acts of violence that were preventable, where people have been critically injured and or died. And as we now know, we have also seen several law enforcement officers who have been critically injured. And now we've seen a law enforcement officer in central Indiana lose his life. This has gone back over three years. We've been trying to bring attention to this. These are just some of the headlines about the prosecutors not bothering to use the red flags law available to them related to the FedEx tragedy. Spelling errors that have been reported, resulting in serious repeat violent offenders being released prematurely or inappropriately from custody, going on to commit new acts of violence towards residents and officers. Computer glitches leading to wrongful releases of serial robbers and such. In addition, no direct access for our officers to juvenile crime records. No direct access for law enforcement officers in Indianapolis to have in-the-field capabilities to know if juveniles or young adults, those 18 to 20 years old, have any prior convictions for gun crimes. That's specifically and critically important for the new permitless carry process for adults, to determine who are prohibited possessors and who are not as adults. And then finally, there's been a refusal, in fact a denial by the courts to often a refusal to accept juveniles who have been arrested, even for crimes involving guns, to be arrested and taken into custody and placed into the juvenile detention center. I think it's important that we take a moment just to reflect upon the seriousness of all this. We have not forgotten, and I think that's what your officers are wanting to communicate to the public. We have not forgotten the senseless tragedy that occurred at the FedEx. 13 people shot, 8 of which lost their lives. It is not in dispute. It is acknowledged that the Marion County prosecutor intentionally chose not to, file a red flag filing with the Marion County court system that was submitted by the Indianapolis Metropolitan Police Department related to this suspect. And as a result, reports show that this suspect was able to go on and purchase additional rifles, which were then subsequently used in this tragedy. Folks, something has to be done about these things. Now, the courts did take immediate steps in an unprecedented move, one of which I've never seen in 25 years, and everybody I've talked to has never seen. The courts publicly stripped the Marion County prosecutor from that process and said that any red flag filings would have to be a direct file to the courts from the officers from now on. They did not want them being screened or going through the prosecutor. Immediately following that, there were media reports that showed that the prosecutor, who had only filed a handful of those red flag submissions, once it was removed from him and then transitioned to the courts, we saw immediately 120 red flag filings that were submitted to the court, almost all of which were upheld and processed through the courts, hopefully saving and protecting countless lives. I think it's also no secret that we have had our share of disconnect with this prosecutor. This is a prosecutor who's made abundantly clear publicly that he does not view law enforcement as a partner in what he does. Folks, I got to tell you, everywhere I go throughout this state and every other state in this country, it baffles people to hear that. I think even residents get it when you watch a television episode of Law and Order, how the process works. Law enforcement officers investigate the cases, they finalize their filings, they submit those to the prosecutor or the DA, and then they work together through the successful prosecution of that case if charges are filed. Yet we have a prosecutor who's going above and beyond to make clear he is not a partner with law enforcement officers, signaling and further demonstrating he is not willing to work with them. There have been public statements made that the Indianapolis FOP should take steps to simply sit down with Prosecutor Mears to discuss these issues. Folks, many of you in this room know we have tried that multiple times, privately and publicly, through direct calls, direct messages, through emails, and through public letters requesting meetings and also outlining our questions to the prosecutor, all of which have gone unanswered. Not even a turn down, just unanswered. To the extent that we have had to issue these public letters, to the extent that we've had to do other press conferences, even to the extent that we had to attend the prosecutor's press conference, public press conference, in which he was announcing steps and charges in the shooting for the suspect in the shooting of Officer Tommy Mangan. The problem is that specifically related to that, the prosecutor acknowledged that he did know that the suspect in that matter had been previously arrested in violation of his parole, and also being in violation of his parole should not have been out. However, that suspect was released, and at a follow-up hearing, the prosecutor again had the opportunity to make it clear to the courts, bring it to their attention to make them aware, and for whatever reason, he chose not to do that. And the suspect was released a second time, and a mere 14 to 15 days later is alleged to have shot Officer Tommy Mangan in the throat. Officer Mangan, as we now know, we saw an update video posted upon him just over the weekend from IMPD, showing that he is continuing to fight for his recovery. He is continuing to have scar tissue in his neck broken down so that he can turn his head. He is continuing to work on swallowing, and he still struggles to talk in spite of the fact he's not supposed to be able to talk. By all medical reports, he should not be able to do that, but miraculously he can. These are photographs with Officer Mangan. I think it's important to note he's not wearing the sunglasses because he thought it was cool. He's wearing sunglasses because he's still having a hard time adjusting to light sensitivity with his eyes from these injuries. His wounds, his trauma continues. Yet our elected officials and appointed officials act as though they're above reproach and not subject to question about their decisions. And I think it's clear that your Indianapolis law enforcement community disagrees. It goes on the upper left you can see, we continue to deal with low bonds for violent crimes. People who are receiving low cash bonds of $500 and an automatic release, even for crimes involving battery, residential entry, criminal confinement, intimidation, resisting law enforcement, strangulation, escape, pointing a firearm, criminal gang activity, stalking, and criminal recklessness. All of those felonies, your Marion County court system have deemed non-violent felonies. I still ask the question, point to any of those that do not involve violence. And yet these suspects, when they're arrested, are given $500 cash bonds and released. And look at what we have seen go on. Since this step of these low bonds has been placed into effect by the Marion County court system, we've seen a steady increase in female homicide victims, many of which are suffering as a result of domestic violence and domestic violence violent relationships. Look at the cases involved in red: battery, strangulation, and stalking. 3 of the highest lethality predictors in domestic violence situations that are given $500 cash bonds and the suspects are released. To the right, we have the case in which a suspect was arrested for allegedly stabbing 2 IMPD police officers, one just above his heart in the chest, the second in the throat, bilaterally across his throat. That suspect is alleged to have ambushed the officers and stabbed them. That is a quote from him that was included in the probable cause, that he was going to kill a police officer. And we later learned out that his bond for a prior felony was radically reduced by a Marion County judge from $25,000 to $750 cash, and he was released and was able to be out and about to commit this crime. We also learned that it was done in conjunction with a Bell organization that the Marion County courts later disclosed they had formalized an agreement and an arrangement with to work with. Since that has become public, that relationship has been suspended. We are still hopeful that that is the case, and we look forward to learning more about that. And finally, the picture below is a gunshot round that went through a windshield of a detective's car while they were trying to intervene and take someone into custody, only to learn that it was another serious repeat violent offender who should not have been out on our streets. Our officers continue placing themselves in harm's way senselessly when we know that these are offenders that should be held in custody. But they still do it on our behalf. Finally, last year, it was no secret. We set an all-time record. This is an image from last year. This was at the point that we surpassed 246 homicides. The reason why that's important is because that was above the record set the year before. We went on to set an all-time record of 271 homicides. So we are now in 2022, where we're coming out of a year of averaging a homicide every 1.5 days in our city. Our numbers of homicides are slightly down as of right now. I can tell you the pace continues to increase. And with that, the numbers of non-fatal shootings and stabbings and other aggravated assaults have not gone down. They have gone up. So, with that, I'll stand for any questions that you may have and hope to address any concerns or thoughts that you may have.
In your career, has the FOP done any similar votes like this before?
I'm not aware of any other confidence votes in my 25 years. Possibly there was something that occurred, but I cannot find any formalized votes. I don't rely upon my own memory. So I go and I talk to active officers, retired officers. No one can identify that. The other thing that I'll tell you is it's not uncommon to see across the country, maybe cities, especially major cities, where votes of no confidence occur on prosecutors or DAs. Unfortunately, that's becoming a more and more common occurrence. But we have yet to find any community that has held a vote of confidence and then voted no confidence on their court system. And here's the reason why that's so important, and we do not take it lightly. But I have made this question clear. If your police officers don't have confidence in your court system, why should you? That is a terrible place for our community to be within. Now, obviously, we've heard some of the rebuttal from our Marion County court system, spoken through others, in defense of them. But I have to tell you, without a doubt, their rebuttals fall short. This isn't difficult. We have met with the presiding judge of Marion County over the last 3 years. We have begged her and her colleagues to take action on our concerns. We have gone and we have met with the Chief Justice of the Indiana Supreme Court, just as we publicly pledged to do. Here's what we've identified. It is not in dispute. The reason why you have those $500 low bond crimes that have been identified is as a result of what's called Criminal Rule 26. It's a directive from the Indiana State Supreme Court that says that all local communities are to start to prepare and try to identify ways to move to a risk-based, non-cash bail bond system. Pretrial release system, basically, without the use of cash. We've never disputed that. The only thing that we have said is that in Marion County, when you're letting repeat violent offenders with new alleged crimes of violence out on $500 cash bonds, you're not doing either one. You're not doing a risk-based assessment, and you're still implementing a cash-based system. Neither one is achieving what Criminal Rule 26 is designed to do. We ask the question, are the Marion County courts accurately and appropriately applying Criminal Rule 26? It has been made clear to us they are not. We have simply asked, could we get our act together and start following the rule correctly? Specifically for known repeat convicted violent offenders. That should be easy to do. But it gets worse. This year in the General Assembly session that occurred, we had public discussions on the record about these issues specific in Marion County, and it was only there that we learned that not only are our judges, I should say our courts, not appropriately applying Criminal Rule 26, but when the question was asked, are they required, the judges, to have training on Criminal Rule 26, the answer was no. So we have a criminal rule that's been in place by the Supreme Court with no requirement for training, and then we have these outcomes. Here's the problem. People are dying, and it's your law enforcement officers that are standing up and saying enough is enough. Other questions?
Are you afraid this is going to deepen the divide between law enforcement and the prosecutor's office and the courts?
I think most officers would tell you at this point, I don't know how much deeper that divide could actually be. And again, all we have been asking is for steps to be taken to correct course here. But we have a prosecutor, for whatever reason, that goes out of his way to avoid that, goes out of his way to even give the appearance of even interacting with our law enforcement officers. And whether he likes the FOP or not doesn't matter. The FOP is the recognized labor representatives for our law enforcement officers. In addition to that, we have a prosecutor that goes out of his way to spend more time telling you what crimes he won't enforce versus the ones that he will. Even today, he has taken those steps to tout as a trophy a recognition for not upholding certain laws in the state of Indiana. I've already said this before. It begs the question then, do we live where we don't have equal application of the law across the state of Indiana by pattern or policy? Is your expectation of criminal justice different in Marion County than it is in the other 91 counties? And is that appropriate? And finally, we have gone to the Indiana State House and we asked the question. It has yet to be answered. Can a prosecutor, elected or appointed, like this one is appointed, can they disregard and not enforce any state law as a matter across the board as a matter of pattern or policy, practice and policy? And people do not want to answer that question. So here we sit. Other questions?
Rick, what does this vote actually mean? Can your organization, where do you go from here?
Well, there's two questions in that. What does it actually mean? It means it's as serious as this. Your law enforcement officers have lost their trust in your prosecutor, the one that's required by the state of Indiana to prosecute crimes that our officers are required to enforce, and at the same time, the very court system that is supposed to dispense justice related to those crimes. This is a terrible place to be in. Again, not aware of it anywhere in the country. People say, so then what's next steps? I think that's what you're asking. What's next steps? Well, next steps will be, we're going to immediately request meetings back at the State House, again with the Chief Justice of the Indiana Supreme Court, but we will also be requesting a meeting that we have not requested yet, which is with the Indiana governor, to ask of him and the executive branch of government what steps they can take to help assist us in Marion County. And finally, don't forget our officers here are having to more frequently seek assistance from the federal prosecutor in this region to enforce crimes, specifically gun crimes, that they cannot get convictions or the suspects held on pretrial release, revolving around repeat violent offenders who are now alleged to have new gun charges placed upon them. Don't forget, we just had a case where our officers had to take a gun case to the federal prosecutor because the suspect involved in that case had 24 prior felony convictions, not charges, 24 prior felony convictions at the age of 57, and was out and about on our streets, again, allegedly with a firearm, again, as a serious violent felon. That had to be charged to the federal prosecutor's office, in which they were able to sustain a conviction. Other questions?
You told me before that you talk about this not being something you do lightly, that really this is kind of the last arrow in your quiver, right? The no confidence vote. Is there, I mean, what took it to this extreme level, and why was there not some other way?
Well, we had run into a dead end, number one. We've tried every opportunity. First, we called for a commission on criminal justice outcomes, where we could bring the relevant professional stakeholders around a table and analyze specific crimes of violence, specifically homicides, non-fatal shootings, stabbings, and other aggravated assaults. With the question being, and this is done routinely on various other crimes, such as child fatalities, let's say, I should say other investigations, child fatalities. We take every one of those and put them on the table, have the relevant stakeholders look at that incident and work backward, not to point fingers at people, but to identify any gaps in the system or any gaps in prior investigations or prosecutions to see if we can fix those so that we don't have these tragic outcomes occur again. That's professionalism. We called for that 3 years ago, and every step of the way, we have been publicly shut down and with a public refusal from elected and appointed office holders and decision makers to do that. The question we have asked is why? But to you, the other half of your question, undoubtedly, when we've had officer after officer being violently attacked, critically injured, watching residents be slaughtered in our community. Don't forget, we had a public report that said 40% of suspects involved in homicides, I should say 40% of suspects and or victims involved in homicides had prior convictions or were out on pretrial release. This is simply what our officers have been saying, that we've been seeing tangibly when we investigate these crimes, is that oftentimes if one or both parties had been held accountable for prior bad acts, one or both of them could not be there for that latest tragic incident to have occurred. That tells us they're preventable. We're simply going to the rest of the system here. It's really like a three-legged stool. You've got the police, the prosecutor, and the courts, right, that are working this process, along with defense attorneys, the defendants, and all those other things, seeking justice. Not a predetermined outcome, but actual justice that holds up the humanity involved, the sanctity of life, as well as the rights of the defendant. Yet we have defendants that are sitting with thousands upon thousands of cases waiting to go to trial. Victims and victims' families who never feel like they're getting justice. We see public comments from family members and actual victims all the time. Even on national news cycles, we've seen that from Indianapolis. And your officers have simply said, why can't we sit down and fix these things? I can tell you in all of our conversations, there is no dispute that there's a problem here. You got a prosecutor that admitted the stuff on the red flag case, a prosecutor that admitted his gaffes in the incident that involved Officer Tommy Mangan, so forth and so on. Sweetheart plea deals that we can talk about. But you also have a court system that identifies computer glitches, unintentional releases, unexplained radically reduced bonds and releases, an unexplained relationship, partnership agreement with a nonprofit organization to specifically bond out people that they place on a low bond and then suspend that agreement. All we're saying is let's get around the table, do what we know needs to be done, and save lives in the interim. But without a doubt, the thing that was the straw that broke the camel's back was when we had the death of Officer Noah Shanavez from Elwood, Indiana. and we've been unabashed about this. We had a criminal offender who is now the suspect in that murder of Officer Chenevez. And when you look at his criminal history, it backtracks all the way back to Marion County. We have confirmation that that suspect was convicted as a repeat serious violent felon. In fact, the court, even in their decision, ruled that offender a habitual offender. And in doing so, gave that offender a lenient sentence. Now, people have criticized us for using the word lenient and using the word modified. If you don't mind, I'd like to respond to that. Turns out, we brought some receipts. Now, we had public statements that were being made that alleged that our statements were irresponsible, inaccurate, and dangerous for simply asking questions and also rendering professional opinions about the involvement of a suspect in the murder of a police officer. Not only is that our role, but I would suggest to you that's our obligation. The original news report, it's hard to see on there, but the original news report that captured the conviction of this suspect some years back showed that he received a lenient sentence. I'm calling it a lenient sentence because here's why. What we know for a fact is he did not get the maximum sentence that was available to him. As a convicted, repeat, serious, violent offender that the court said and deemed formally was a habitual offender, there was nothing to demonstrate that he deserved any kind of consideration from the court once he was convicted for the sentencing that was available to him. Instead, as this shows, the suspect in 2006, 2007 received a 25-year sentence from the judge in that matter. However, here's the problem. Within the news article, the judge is even quoted to note that it's very rare that somebody can shoot at police officers like he was convicted of doing in 2007 for a 2006 incident and not be convicted of attempted murder. Knowing that, the judge still gave him a lower than maximum sentence on the crimes that he was convicted upon. So when you talk to the average citizen, they say, I don't understand what this means. Well, here's what it means. These are the public declaration of the crimes that he was convicted on and the sentencing that was administered. If you take that, you've got 7 years for a criminal recklessness conviction, 18 years for a unlawful possession of a firearm by a serious violent felon. But you also have 3-year term for resisting law enforcement, felony resisting law enforcement, which is a violent crime, as well as a 3-year conviction or sentence for possession of a controlled substance, and an 8-year sentence for a felony carrying a handgun without a license conviction. Now, I'm not a very smart man, but I'll do this. I'll do this, and you tell me if I'm wrong. Here's what I do. And by the way, here's what most citizens do when they look at their justice system. They say 7 years, 18 years, 3 years, 3 years, 8 years. And they add that up, and they say, that's 25, plus 3 more is 28, plus 3 more is 31, plus 8 more is 39 years. So when the public adds that up and says, well, the judge sentenced him to all these years, that's 39 years. Well, how in the world does he come out with 25 years? Well, it's because the sentence was modified by the court to where 3 of the 6 felonies, half of the felonies, ran concurrent with the other half. That means they're not being served consecutively. That means that while half of the crimes are being served, the other ones are being served at the same time. That's what takes it from a 39-year sentence to a 25-year sentence. Yet the maximum available was 33 years. Okay? So even if he sentenced him to 39, and let's just stipulate the maximum he could give him was 33, that means 25 years was less than the maximum, which is lenient for a habitual, repeat, serious, violent defendant shooting at officers in our city, and it was modified to run concurrent, cutting it even from 33 to 25. And then the citizen sees at 25 years, the convict only serves half of that. So that's how they see a person convicted of shooting at Indianapolis police officers serving anywhere from 12 and a half to 13 years only, and then being released back out onto our streets. Now, publicly, we've seen comments that have said that we're still wrong, suggesting that it's still not a modified conviction. Here's the problem. These local attorneys who form the Indianapolis bar, when they issue these public statements condemning our comments, the problem is this, is we have a myriad of other attorneys who are contacting us and saying that's not correct. Not only was the sentence modified on the front end, and you call it whatever you want, if the court wants to say that's not technically a modification, any civilian looking at that says that's modified, that's changed, that's less than what it says that it is. But we've had other prosecutors say the same thing. The Madison County prosecutor quoted on your channel, Vic, on Channel 6, saying, he says, quote, "It's very disappointing to me a person with this kind of record shoots at the police a number of times and has his sentence modified." That's not Rick Snyder saying that. That's not the FOP saying that, who they publicly condemned. That's another prosecutor, a fellow attorney saying that, who's now handling the murder of the police officer. Yet we saw no public condemnation of his statement. Now, he went on to say, not only was it modified, but he said, "I just don't understand that." That's as a professional peer. And says, "I don't want to place blame on anyone. I just think there's a number of problems in the Marion County court system." Sounds like he lacks some confidence in the Marion County court system, as do our local law enforcement officers. But it goes on from there. Additional receipts show that the defendant's sentence was in fact modified through public documents that shows that on the back end of his conviction, when he could have still been in prison, the same judge in 2019 ordered community corrections release through a community transition program that's referred to as CTP. Doesn't have to do it, up to the judge. Judge approved it and signed it right there in 2019. Same judge, another public document, shows, it's highlighted here, hard to see, but shows, guess what, when the decision was made, there wasn't even a hearing that went with it. There was no hearing on the matter, it was just an automatic signature and signed off on. Meaning that we also found that the prosecutor did not object to this. There's no record of the prosecutor objecting to this community transition program release. In addition, under the definition of community transition placement, the program release, it describes it as being a court sentenced by the court and or quote unquote modified. That is the definition of it. That is what we have said. So I go back to this again. Seems silly, seems drawn out, but here are the outcomes. Remember, I talked about criminal justice outcomes. We have a dead cop. And we have made clear throughout the last 3 years, heaven help you if an officer loses their life, when we see that we had a judgment that was made that emboldened a violent, habitual offender. People want to argue, well, could he have still been out even if he had served the max? Maybe he would, maybe he wouldn't. That's not the point. The point is, because of our system being lenient, modifying sentences, and not giving the maximum on cases where it's absolutely appropriate, violent offenders are emboldened and they go on to repeat their violence once they're back out. That's the problem. That's why we say they're preventable. But look at the quote. Look at the quote from the sentencing when this occurred, that the same judge said, when you mix those things, illegal drugs, your mental illness, plus guns, quite frankly, you are lucky you haven't killed anybody up to this point. Here's the problem and the inconvenient truth. He went on to do just that, is what it's being alleged now. So if that is the case, and that is proven, that shows that this could have been a preventable death and a preventable crime. And again, I respect Mr. Jimmy Boyles. He is a renowned legal mind, scholar, and an attorney, not just in the state of Indiana, but in the country. But I have to tell you, and I will tell my friend Mr. Boyles face to face, public comments that he made stating that you can't go around, his word, attacking the courts and attacking the prosecutor, that you can't do that. Well, one, nobody is attacking them. They're simply pointing and focusing on their outcomes and talking about how to correct that. But if the position is that our courts and our prosecutor are above reproach and no one can ask tough questions of them and the decisions that they have made, no, sir, I disagree, and our membership disagrees. Not only is it our role to do that, but it's our responsibility as citizens of this state to do that. And we will continue to do so. That is why we stand and you see the outcomes that you have. Other questions?
Would you mind clarifying again how many members voted? I know you said there was hundreds upon hundreds upon hundreds. Was there anything more specific?
I explained to you why I would not do that. So the answer is hundreds upon hundreds, a lot, and a significant sample of our membership to make very clear where our membership stands, just like any other vote occurs. The reason why we don't would be the reason why you're probably asking. Try to compare, try to excuse, try to dilute whatever the outcome was. What I can tell you is it's one of the strongest turnouts we've ever had.
In the question it was posed as presented, do you have confidence in a Marion County prosecutor? Was the name Ryan Mears or the current prosecutor included at all in the survey, just so we can clarify?
There is only one prosecutor,
And a Marion County prosecutor.
and the Marion County prosecutor is Ryan Mears.
Okay.
All others are deputy prosecutors.
Rick, this is so that this is basically your line in the sand. You have no, why would?
Your police officers are telling you that your system is broken. We have told you it's been hijacked by intentional decisions that are being made. These aren't like fractures in the system. These aren't like things that were unexpected, we couldn't foresee, and therefore we're going to go back, we're going to tweak them, we're going to fix them. They keep happening over and over and over and over again. We have a lady that was beat to death with a hammer by a repeat violent offender that our system let out as a repeat violent offender on a low bond and unnecessarily. Should have never happened. She's dead. We have a young man who was murdered by a repeat violent offender out on a low bond. Should have never happened. He's dead. I have this police officer plus countless others that have been violently attacked, critically injured. Should never have happened. Preventable. Yet here we stand. And for the life of me, for anyone in our system to say, we're above reproach, we don't stand for any questions, and we're not going to sit down and fix this, is beyond us. So the system is broken. We have got to get people around the table. If it means we've got to jump up and down every day to get people's attention, that's what we will keep doing. Now, as I've said publicly, I want the community to know, your police officers are not going anywhere. We love you. We risk our lives for you. We want to keep you safe. We are simply asking everyone to get behind us, get with us, to make sure that the rest of the system does their job. And they pull out all the stops to do everything possible to keep our community safe from the repeat violent offenders we're consistently going up against. That is all. And for the ones that are risking their lives doing that, the ones that have bullets coming through the windshields, the ones that have been shot in the throat, stabbed above the heart, stabbed in the neck, I don't think it's too much to ask. And in return, they're going to keep standing the line in spite of all of this. But at the same time, we're going to shine a light on it. Other questions? Vic, I would agree with you. It's overwhelming, and it should be. We're overwhelmed that we're doing this, that we're even at this point. But again, I can tell you our membership made very clear it wasn't even a question. It was demanded that we move on this now. And then they turned out in the manner that they did and made it very clear where they stand on the issue. What else can we do? I mean, literally, I would take any suggestions of something else that our officers can do differently to help with this. They're arresting the folks doing it. This is what I keep saying. The police are not your problem. Time and time again, every one of these revolving door issues you see, what's the common denominator? Every single one of them involves an arrest that was made beforehand, and the latest one. By who? The police. So what else can they do differently? They charge the crimes. They charge what is there that they have probable cause for. It's noted in the records and in the reports, the prior criminal history, just like it was when this suspect was released that allegedly went on to shoot Tommy Mangan. Noted in there, his history. Viewed. And yet what did they say? A one-letter typo. This is what your judges are telling you. A one-letter typo in a name resulted in a violent offender being let out into our community. If they expect people to believe that, we got a lot of work to do. Because it isn't just our officers are putting a name down. By the way, our officers didn't misspell the name. The courts did. But the officers are putting date of birth, social security numbers, all other identifiers to cross-check and confirm so that does not occur. And not only did that occur, but then it occurred again with a serial robber. We ought to be pulling the rope here, stopping the presses, and fixing this. Because it begs the question, how many other folks are unnecessarily out on our streets that can wreak havoc like this? And who is the next victim? But I want to make clear, we shouldn't just get hung up that it's a court system problem. There's a check and balance in this, which is the prosecutor. But we got sweetheart plea deals that are occurring, and the courts aren't a party to the plea arrangements. Those are special agreements made by the prosecutor, again, letting serious offenders out. Other questions? Thank you, guys. I kept going off, so I pushed a button on it. I hope it didn't stop.
No, it's going good.